do you want to walk us? We'll pull the bill up. Do you want to walk us
Yeah,
through
let
your
me
thinking?
see if I can get it up here. If you bear with me for a second.
Okay, Nathan could probably post it as well. I mean, could put it on our screen as well.
Is also posted.
Okay.
Just bear with me. My computer is being a bit surly. Okay, I have it. Excuse me. But let me just back up and just talk for a couple seconds as to what the objective of this amendment is. It's to deal with two issues. One is improper payments, and the other is fraud. And later in the bill, towards the end, in sections 11 and 12, of the amendment, later on in this, there is a better definition of what we mean. But essentially, improper payments means money being paid to people who aren't entitled to it. And that may be criminal, it may be accidental, it may be due to delays in the department dealing with their adjudication. It could be a number of reasons. And there, we certainly have included in this amendment the ability of the department for good cause to elect not to attempt to collect that back. And this is, I think, particularly true in terms of small sums that have been inadvertently overpaid. But there is a judgment involved in that. The bigger concern, though, is fraud. And fraud is intentional and deliberate misrepresentation of material facts resulting in the loss of money. This is activity that we believe is actually covered by existing law. And we discussed this previously, and we, of course, had some testimony from Vermont Legal Aid with some concerns about it. And what I elected to do here is, rather than proceed with the amendment that I previously discussed with you, to say, let's step back and let's do enough of a study of these issues involving all the various stakeholders, meaning business and worker interests, the Attorney General's office, the department, and Vermont Legal Aid, and others who may have an interest in it, to try to come up with something that protects the state and protects the fund from losses due to fraud and improper payments on the one hand. On the other hand, does not go after people who are innocent. And so if we look at the bill, the first portion of the bill are a series of findings. Do you want me to go through the findings, or do you think this is clear as it is?
I don't think so. Let's wait for Damien on that quickly, but let's.
Okay.
The findings are not really changed much.
No, they have not changed since they were in the previous version.
Okay.
I think the only thing that's relevant to the issue of findings is it's big. Both numbers are large numbers that ought to at least get our attention. That's really the point.
Okay.
As we go to fraud and overpayments and detection, this converts the activity that was in the last amendment to a study, and the study would be done and reported back to us in time for action next year. I put that in specifically because there are concerns, particularly about fraud, that we certainly see nationally, reported by the Labor Department and others, that fraud is on the increase in this time of COVID, because we are targets of opportunity, particularly from organized actors who are seeking to provide false information, et cetera, in order to commit fraud. It places the burden on doing this reporting on the department. And my rationale is the department is probably best suited to do this, since theoretically, right now, it is their responsibility. And there we're asking the Commissioner of Labor, and I did have discussions about this with the Commissioner, who agrees that it's in his bailiwick, to produce a report regarding the detection and prevention of UI fraud and the reduction and effective recovery of overpaid unemployment insurance benefits. With respect to fraud, this report would review the department's existing practices for detecting fraud and preventing claimants from intentionally misrepresenting or failure to disclose material facts. So both with respect to fraud and with respect to improper payments, there's an emphasis on figuring out how to prevent these things from happening, because that is probably the best way to deal with fraud. Is if we can prevent it from happening in the first place, we won't have to investigate and mitigate and recover. To identify strategies and measures employed by other states to do this, to look at potential actions for improving their ability to detect fraud and to prevent claimants from committing fraud, and to identify when it may be appropriate to refer things for criminal prosecution. If you recall, in the amendment that I presented to you earlier, I created a standard for the kind of fraud that would be referred to a prosecutor, and it was a limit of $900, and that was based on how we define insurance fraud in other statutes in Vermont. But here I'm leaving it open so that the department can come back with what their recommendations might be. And then also, we know that dealing with fraud and also dealing with improper payments is something that's not free. We know that there's some resources in the department that are dedicated to these. And the question is, what's the proper resources? Are there additional resources necessary to do this? I know certainly it's been my experience, so with respect to fraud is and improper payments in other contexts, is that you generally look at resources as to whether or not there's in fact a sufficient return on investment. That return on investment is either collecting money back or in deterring future bad behavior and stopping it before it becomes more costly. With respect to overpayments, again, reviewing existing practices, identifying strategies employed by others, potential actions for improving the department's ability to prevent, reduce, and collect overpayments, and then identifying instances in which an individual's liability potentially should be reduced or waived, and the criteria that the department would use to make those determinations. One of the problems we have right now is we have a substantial amount of waivers of fraud, or rather improper payments, but we don't seem to have any standard to decide what is waived and what is not. The department will consult with the Attorney General, the Department of State's attorneys and sheriffs, representatives of employers, representatives of employees, et cetera, in order to come up with its conclusions and then report back to us. And then the definitions that I mentioned before are contained in the amendment. That's it in a nutshell.
Thank you, Senator Brock. I really appreciate the direction you're taking here. We do need to hear from, I assume the Attorney General will not have a problem him being consulted, but
I think they want minimum consultation because they don't think it's their problem.
So we'll hear from them. It's unfortunate that the department is not able to be with us, but we do have to be determined for tomorrow morning so we can continue with this. As I've said before, and I don't know whether you've had objection, we have a resident expert on the issue of misclassification in UI and Damien. We saddled him with a report a few years ago. I thought it would be a 3-page report. Turned out to be 35 pages or something like that. But it'd be interesting to know the efforts we've taken in that regard from the department, whether they feel that's working. But in your reading, I don't know if you've done much on this, but it sounds like you've done at least some research. Have you heard anything? When I was dealing with misclassification many years ago, it always came back to me. There's fraud on both sides. It's employers.
That would not surprise me at all. I've heard that.
Yeah. So it may be an opportunity to do both here. And, when it's intentional, absolutely. I don't think anybody has sympathy here. It's you've correctly identified the issue, as you always do, in terms of return on investment. That's one thing. But assuming there is a return on investment, and assuming we're fair in approaching the innocent mistakes, I guess I respect your assessment that this is a serious problem on the intentional side on both party side. So,
But, one of the things that I was tempted to put in and I didn't because I kind of assumed that it was implied, which is sometimes a mistake, is that we need better numbers from the state as to what's the extent of either of these problems. I've got the numbers, and by and large, my numbers have come from federal resources as opposed to state resources, which always, there's always that issue of a mistake. And I know I found one mistake involving numbers that the Labor Department reported elsewhere, which, does raise a question. But we certainly know that from the national trend, these are big problems. And if the numbers that the federal government are reporting, the $55 million in 10 years of losses due to improper payments, that's got to get our attention.
right.
And also looking at the 1 year where we do have some numbers about improper payments and the recovery rate is quite low. And that should be.
It's the third.
Yeah. So
A third.
you and I talked about this before, and you may be right. I mean, I look at the 55 million and I say, okay, that's $5.5 million a year. We're paying out benefits of about $80 million a year, other than that pandemic situation. So it's less than 3%. I don't know if that's shocking or that's normal. I do know that I've read a bunch of stuff that said fraud, purposeful systemic fraud has picked up substantially during the pandemic, as it has with income tax returns, as it has with people going after other people's $1,400 stimulus checks, generating that. I don't know if that's just a aberration for this year or not.
No, it's one of the few growth industries we have.
Yeah. So, I'm supportive of this if we do it right. I don't know if other people are or not, but we'll hear more from the department, who will be saddled with this report, and will have a better assessment of whether they think there is a return on investment, how we do compared to other states, and things like that. But that's where I'm at now. We could have Damien. Is Charity with us? Or
No,
is-
Josh is.
Josh is, okay. Let's, Damien, why don't you just, in 5 minutes, could you just, Senator Brock has sort of walked us through, but could you just, you're so eloquent at this, could you just walk us through the bill before Josh testifies? And Josh, this has changed, I assume, markedly from versions you've seen before, so.
Yeah, good morning, everyone. So as Senator Brock said, Section 11 is findings that you've seen in his previous versions of the anti-fraud amendments here. But Section 12 is a new approach here. It would require a report by next November 15th, which would give time for both the House and the Senate to get in drafting requests related to any of the findings and proposals in the report. For purposes of unemployment fraud, it would focus on sort of a review of the existing practices for detecting and preventing fraud, and then identifying effective strategies and measures that other states have taken to identify and prevent UI fraud, and then identifying potential actions that the department could take based on that review and look at other states. As well as the next piece, which is examining and identifying when it might be appropriate to refer instances of UI fraud for criminal prosecution. One example that jumps out.
Can I interrupt you for a second? So as of now, if they found a serious instance of fraud, can they refer, and is there a fraud statute out there that would subsume unemployment fraud for prosecution?
I don't see anything in the law that prevents the department from referring. And I do see fraud statutes, for example, identity fraud, which has been an issue throughout this pandemic, is prohibited under our laws and could be criminally prosecuted. So that's an instance where there seems to be a real clear pathway to referring an effort to defraud the UI system that also involves identity theft In that instance, you could have a clear referral. With some of the other fraud statutes, some of them are very specific. We have them specifically related to, for example, criminal workers' compensation fraud. I think the question here is when it might be appropriate. And then the other question is whether they can be effectively prosecuted under existing statutes, or whether some of the existing statutes might not be a good fit and may need amendments. So I think currently you could make those referrals, but the question that remains for me is just whether, and I'm not an expert on criminal fraud, and it's just whether there's a good fit across the board or only in certain instances, such as the identity theft.
So we could ask Josh that question, but it would seem if you want to get at fraud, you may need to say the study should look at whether the fraud statutes need to be amended. Because I thought we heard that they removed fraud from the UI system, and they have a specific things you could do with, forget about identity fraud, but let's say an overpayment fraud where someone's putting in false numbers and you get up to $10,000 in extra benefits. If you say specifically in the UI statute, this is all you can do in those circumstances, it may be legislative intent that, especially if there was a repeal of a criminal statute long ago, that there is no tool for state's attorneys or the AG, even if they got a referral, to do anything with it.
So the UI statute change that you're referring to occurred a little over 10 years ago. And what it did is it replaced a provision in the UI statute that provided for a nominal fine and a jail term of, I think it was up to 30 days. So I think it was like a $50 fine and up to 30 days in jail for violations of the unemployment insurance laws for which no other penalty was applied, and replaced it with an up to $5,000 administrative fine. Those discussions were before my time, so I don't know what the intent was, but that was what occurred there. It didn't actually amend anything in the Title 13 fraud statutes.
Okay.
So I'm not sure that we could read an intent not to refer an instance where someone has both attempted to defraud the UI system and in doing so violated a criminal statute. I'm not sure that we could necessarily read an intent to prevent the department from making the referral to law enforcement authorities to investigate and determine whether there's a case at that point. But it is clear that we intended not to have, a jail term applied for the UI violation itself, which is what the old statute used to have.
So with Senator Brock's permission, could you make sure there's a review of the criminal statutes to make sure there's an effective?
There already is in the language here.
Oh, okay.
It says for,
Yeah.
it's on page 4, lines 3 to 6.
Yeah.
And it specifically directs them to examine whether the unemployment
Okay,
insurance
thank you. I
fraud
see.
that's
I see.
appropriate for criminal
Yep.
prosecution
Yep. My
can
bad.
effectively be prosecuted under existing statutes or whether amendments are required.
Okay, great.
So, yep.
And while we're in that section, Mr. Chair, may I ask, we had made a passing remark about misclassification being included in here, and I'm not sure I see it. So
No, I don't think it's in there now.
It's not in this.
It might go in there.
to me, that's a much bigger problem, and I'd love to compare actually the cost of, because from what I've heard, that's a much bigger problem than fraud even. I mean, it is a form of fraud, but I mean, it's more than the claimants. So I would really appreciate having that added.
I have no problem about adding it.
Yeah, thank you. Yeah, because actually, as you may remember, the House Commerce Committee dealt with this, and Damien remembers this. I mean, there was a big misclassification issue that was dealt with. You know, we tried to solve it. I remember meetings in House Commerce with everybody from DOL. Do you remember those, Damien? when we tried to get at this. Yeah,
It's hard to forget.
it is hard to forget. So I think it would, I'd love to honor those conversations. And Heidi Sherman, I mean, I could now, they're all coming back. I would really love to.
Well, I know we have made some progress in that area, because when Damien did his report, what we found is there was a law that was passed around a decade ago that was supposedly the cure-all for misclassification, which was a debarment provision where you would, if you were found to be misclassified and the department was finding misclassification in a number of cases, then that would be referred to BGS, and they would put the person who misclassified the business on a list of shame, so to speak, and also bar them from any further state contracting. And like over 5 years, that list had become moribund and there were no names on it. But now there was a pushback, and now there are apparently hundreds of names on the debarment list. So at least that tool seems to be working as intended, but I'm sure there's more study that could be done on the issue.
Right.
So
I remember that.
let's continue on, Damien.
Sure. So the next part, or the last piece on the fraud front, is just identifying additional resources, including staff, funding, and training that may be necessary to enable effective criminal prosecution of UI fraud. There may not be sufficient resources at either the Attorney General's or the, I'm getting a message that my internet connection is becoming unstable, so I'm going to turn off the video.
Yep.
But we heard that there are insufficient resources at both the Attorney General's office and the state's attorneys with their current resources to bring on a large caseload or an additional caseload. And so this is something that this is looking at here is additional staff or funding necessary? Is additional training necessary, either for departmental staff or for staff at the state's attorney's or AG's office to better coordinate this? So that's what this last piece is looking at.
Well, let me just add that part of this also, in terms of the study, is to determine the extent of the problem and also some of the decisions made as to what things would or would not be referred for potential prosecution, as well as to whom. And that would give better numbers and better targets as to what the resources necessary to do it. After we have to decide what we're going to do before we decide how much do we need to spend to do it.
And I guess we'll hear from the department tomorrow, but it's not a solution because the department is so strapped in all different ways. But I would assume that some of the work that could come out of this report to improve the situation could be paid out of administrative dollars that are either in the fund or are supportive of the fund with federal administrative support. So there may be a resource there. I can't imagine that something like this would not be part of that whole system, but though the system is clearly under stress. So,
but we know right now, for example, of what's happening elsewhere, that this COVID situation has led to a significant increase of fraud across the board. That's been widely publicized, and the Inspector General of Labor has in fact emphasized that. So it would lead me to believe that that is a potentially good source for one-time funds to, in effect, swoop in on some of these problems that exist right now, although that level of resource may not be necessary to continue once the pandemic has passed.
right. Okay, so Damien, are you have more? Because I want to turn to Josh in the 10 minutes we have left.
Sure. Just the other piece essentially looks at the same general pieces regarding existing practices and effective strategies and potential additional actions the state could take to prevent, reduce, and collect overpayments. And then the final piece of that is just to identify any instances in which an individual's liability for an overpayment could potentially be reduced or waived, and the criteria that the department would employ determine that. One of the questions that came up early on in this is, what about the individuals where it's a de minimis or accidental violation, and should there be more clarity about how to when the commissioner should have discretion to waive or reduce an overpayment versus when the overpayment should be collected in full, such as a more egregious issue or where there's some intentional misrepresentation. So,
Okay.
and that's it from my walkthrough.
Great. Thank you so much. Josh, welcome. We have about 8 minutes, probably more time than you need, but you've listened to this conversation, and the floor is yours to give us any thoughts you had and your resource questions. And I know you guys are a little bit in the misclassification world already, but floor is yours.
Sure. Thank you, Chair Sorokin, members of the committee. Joshua Diamond, Deputy Attorney General. We welcome the opportunity to participate in the report and consult with the sister agency at Department of Labor to address some of the questions that have been identified in this proposed amendment. I think on the greater picture, our office already works on a task force with Department of Labor, Department of Financial Regulation, and DOL that was, I think, stood up through DOL in response to some of these reports about identity theft and unemployment insurance fraud post-COVID crisis, or as a result of the COVID crisis. I think we've been involved in 2 investigations with VSP, who's also a participant in that task force. We weren't able to bring prosecutions because we weren't able to find the perpetrator of the fraud. These are complex internet crimes from time to time, and sometimes you just can't track down the perpetrator. So that's part of the dynamic that certainly we've run into. And our criminal division is set up in a way to handle the more complex crimes. We deal with murder cases, sexual assaults, ICAC, internet crimes against children. And so we don't engage typically in kind of, I don't want to call it routine, but what might be high volume, small dollar crimes. Those typically get referred out to the state's attorneys. So from that aspect, we certainly have resource constraints, but happy to work with Department of Labor to address the issues that have been identified so that you all can develop policy on the issues.
Your reference to some post-COVID work with the task force, that wasn't in any way a legislatively established task force, was it?
To be honest with you, I don't know, Senator Sorokin.
Okay. Okay. So that came to light because of some serious practices you saw out there and trying to actually track down what was going on and trying to potentially enforce some statutes against them?
Yes, my understanding was that there became an awareness when the first stimulus dollars came out back in the spring or early summer in response to the COVID crisis, that there were concerns about fraud in the sector of unemployment in particular because of the enhanced benefits. And as I said earlier, I don't know who, I guess, was the impetus. I thought it was Department of Labor that asked folks to get together. And so we participated in those efforts.
Okay. And I assume you don't really have any expertise, or even your office wouldn't have any expertise of really the extent of the problem this study is attempting to address. That would be mostly the bailiwick of the Department of Labor, correct?
That is correct.
Okay. Does anybody have any questions for Josh? Damien?
I have something to add after you're done with
Okay.
questions for Josh, just related to what we were talking about before with the study.
I don't see in my screen, I don't have.
Senator Clarkson has a question.
Okay, I don't have Senator
Allison has
Clarkson.
a question.
Go
Uh,
ahead.
Josh, You have the ability to also find out sort of how prevalent a problem this is, both misclassification, which we're pretty clear on, and overpayments with the 50 other attorney general's offices around the country. They would be, obviously, we don't want to reinvent the wheel. They must, they prosecute these cases, I assume. I mean, that's you are the prosecutor for the state and the state agency. So I would assume there's lots of experience out there with other AG offices.
There may be. It's not uniform. Some states, such as Connecticut, doesn't have a criminal arm in their office. That's,
really? Huh.
Yeah. And then other states, I could be wrong on this, like New Hampshire, are focused on serious felonies, which might include unemployment insurance fraud. So it depends. And I'm certainly willing to reach out to our trade association, the National Association of Attorneys General, and see if there's any collection of data on this front. But I don't know as I sit here today.
Right. So I guess the report, in my mind, helps, in fact, settle, just explore this issue further and understand what other states are doing. And I think as long as we include the misclassification piece, I'm reluctant to continue to criminalize. We're in, anyway. Yes, I would support this if we also included the misclassification, which we already know is an area that is having a big impact on UI.
Okay, thank you, Josh. Damon, you said you had a comment. Go ahead.
I did. It actually goes to Senator Clarkson's misclassification comment. So I just wanted to remind the committee that there are 2 reports due from Act 85 from last year, which was the misclassification bill that this committee passed, or that the legislature passed, which added joint enforcement with the Attorney General's office for serious misclassification. One is from the Attorney General's office regarding how that process has been going and whether there's any recommendations to improve it. The other is from the Employee Misclassification Task Force, which was codified under the leadership of the Attorney General. And that again goes to, both of these are due by January 15th. And that one again regards the government-wide sort of task force-led efforts at reducing misclassification, as well as potential legislative changes to address shortcomings or difficulties that misclassification task force has identified in relation to seeking joint enforcement of misclassification provisions, and potential legislative changes to better enable the Commissioner of Labor and AG to seek a full combined range of penalties and remedies through joint enforcement of those provisions, and then whether to expand those laws or add a private right of action related to employee misclassification, or a private attorneys general act to allow people to file suits and then give the Attorney General's office an opportunity to take over the case. So this was added last year, just before the pandemic.
Got it.
And when is it? January 15th of 2022?
Those reports are due January 15th, 2022. And then there's a final report from the Attorney General's office on the joint enforcement due in 2024. So these were things that were added to that structure last year to look for additional ways to move forward and also to sort of get a feedback on how that enforcement is going. And as I said, this was all passed just before the pandemic.
Right.
So, I don't know what the status of any of that
So maybe
is, but it's in there already.
So do you have advice for us? I mean, it
Yeah.
almost sounds like we don't need to add anything to this bill. There's a parallel track going on misclassification.
I think that's the question I have for the committee is, the concern I would raise is that you may be duplicating
Right.
the work that you've already required last year. And so I think the question I would raise is there something that's not covered by those reports that you would want to address in this report? Or do you want to wait to hear from those reports and then move forward based on that? And I can send you the language of the reports if the committee
Why don't
wants
you
to look
do
at
that?
them.
And we'll take a look at it overnight. I'm inclined not to saddle this report with
Right.
additional requests if
I'd
that's
agree.
all proceeding. I'm sort of sorry they're not on the same timetable, but it sounds like they're only 2 months difference here.
That-
Maybe we could move up the other one to November 15th as well. And so we would get both of them simultaneously. But that's
Well, that's
good.
just
Good
a
to know.
question.
Thank you.
In the
It's
event-
amazing how quickly one forgets these things.
Yeah.
Let me just ask a question about the misclassification reports in terms of the due date that they have right now and the date that we have for getting bills in before cutoff.
Right.
Is that a problem that suggests that we should look at how to make these dates concurrent?
Well, that's what I was just suggesting. I
Yeah,
forgot.
I
I've forgotten about the due date for
Yeah.
draft. That applies to the Senate as well, right? In the second biennium?
Well, we have a much earlier
Does
deadline.
we have a longer.
Well, no, we have shorter. We're due,
Is it shorter?
I think our bills are due,
In the
have to be
second year.
drafted by the first week of December.
Yeah.
Okay.
so
Okay.
the let me just see if I can find that particular. Okay, here we go. During the adjourned session of the biennium, no bill may be introduced by a senator unless it has been filed with legislative council on or before the first weekday of December. So the bill request has to be filed by the beginning of December. The contents have to be approved no less than 25 calendar days before the opening of the session. But then you don't have to get co-sponsors and approve the bill for introduction until the second Friday after the commencement of the session. So that was the change last year, was to extend the approval deadline in terms of introduction, but approval as to contents is still, that's still looking at early to mid-December.
So why don't we do this? Just have ready a new section to this bill that advances that reporting date to the November 15th. for
Yeah.
Okay.
next year.
And anything else we need to do to reference that work so that we can coordinate it.
Yeah, that would be good.
Okay. Thank you so much, everybody. And appreciate everybody's work on the floor on both sides the last few days. And we'll see you tomorrow at 8:30 and we'll button up this and we'll probably have another agenda item on the docket for tomorrow. I don't know exactly what yet. But thank you all again and we'll
Right.
see you